this is Pat McDonald, your host for Vote for Vermont, where our tagline is Listening Beyond the Soundbites. My guest tonight is Ed Stanak, who used to be, giving you a highlight here, District 5 Coordinator for the Environmental Commission.
That's correct.
Ed, thank you very much for coming.
Great to be here.
We go back a few years.
We sure do.
How do you like that tagline, Listening Beyond the Soundbites?
Catchy.
My example is if they say free, ask questions. So anyway, so I just wanted to tell you why I invited Ed here. Some of you may know Annette Smith. She's been on this show a couple of times, is a anti-wind activist and executive director for Vermonters for a Clean Environment. When she and Mark Wentworth were on the show maybe about a month ago, we were talking about the fact that wind projects are not included in Act 250, which I didn't know and was completely astonished by. And I said, who can I bring on the show to talk about this? Because it made no sense to me whatsoever. And therefore, I asked Ed to be on the show, and he graciously said yes. So, but first, we always ask our visitors and guests to say a little bit about themselves. And if you could give us a little bit about your background, it's an interesting one for sure.
Well, I always begin by saying I'm a product of 8 years of Jesuit schools.
Oh, bless you.
They had a slogan, give us the boy and we care not who has the man. Moved to Vermont in 1973. Was employed by the state of Vermont, as you mentioned, as an Act 250 coordinator for almost 32 years.
Wow.
Served on the Barre City School Board for 6 years, including 1 year as a chair, and also served for 6 years as president of the Vermont State Employees Association.
Which is where Ed and I met,
That's
right?
correct, that's right.
Yeah, and then after that, you ran for?
I ran once for state senate, state rep, and then I also ran in 2012 for the state attorney general.
Oh, that's right, of course, that's right. Now, are you an attorney? You don't have to, are you an attorney? Do you have a legal background?
I did the 4-year clerkship program.
Oh, I see.
But when it was time to take the bar exam, we were going to have twins, and so I decided I need to have a job.
You have the information in your head, though. That's a very good program. I should do a show on that, because what a great way to get a law degree. And
Marilyn Scoggin on the Supreme Court.
Yes, I know. I actually know 2 friends of mine who are in fairly large law firms here who did it that way. Yep. I love Marilyn. Yep. So I was told that besides all these other things you do, you hang around the State House with the green vesters. And I realized when I wrote this, and I said, how did you become so vested in environmental issues? And I didn't realize I was using a play on words here. Who are the green vesters?
The green vesters are folks from all over the state of Vermont who found each other through an affinity of questioning these large industrial scale wind and now solar projects. Right. A whole host of impacts. And we are from an incredible mix of politics and backgrounds. And Sally Colopy from Swanton Way had the wisdom to come up with a way that we would be identified as a cohesive group in the State House, and she came up with the green vest, thus the name.
Oh, that's great.
Yep.
Well, I admire your passion for this, because I must say in the beginning, I got it and I thought, well, this is a good thing. Right. And then when we started talking about the wind towers and what it has to do with the mountaintops and the roads that go down and wildlife, I thought, well, and then we were doing shows on health that we're going to talk about tonight, and it's like, really?
Well, you know, I'll never forget, I retired from Act 250 in December 2011. In January 2012, I got a phone call from a dear friend of mine through the union who drives a snowplow and a selectman in one of the towns in the Northeast Kingdom. He said, Ed, what do you think about these windmills? Because they're popping up in the Northeast Kingdom. And I said to him, Larry, what could possibly be wrong with alternative energy?
Exactly.
But I did my homework, and lo and behold, I found that what was then the Public Service Board, now the Public Utilities Commission, was doing an inadequate review of impacts on those ecosystems above 2,500 feet, inadequate review of impacts on habitat areas, necessary wildlife habitat, not a good review on aesthetic issues, but more to the point, they were approving projects where the transmission facilities were inadequate. There's absolutely no assurance that the power generated by these facilities will stay in Vermont. Most likely it goes to the highest bidder, i.e. out of state.
Oh, right.
And last but not least, well, these health impacts, which I could not believe when I first heard about this, the impacts from the so-called infrasound, which among other impacts disrupts people's sleep patterns and has other impacts. So having learned all that, and gone up the learning curve, I started going to the State House and parked myself there for 5 years now, working on efforts for legislation and on those issues.
Yeah, we had some people from the Northeast Kingdom come on the show about 2 years ago, and when they started talking about the health impacts being nauseous, and there's a family down south that actually moved.
Correct.
I mean, then I heard them testify in the state. I don't understand our legislature, but I mean, how do you not pay attention? So I know you've been involved in the Lamoille Valley Rail Trail, Northeast Mineral Group, the Rock of Ages, and that thing's still going on now, is it not?
We could do one show on each of those topics.
I'm sure, well, especially the Rock of Ages. That's interesting because we're here in Barrie. I pay attention. So you bring an extraordinary expertise because of Act 250. And when you help the neighbors that are involved in this, what kind of advice do you give them, and the knowledge you have about Act 250? I mean, you must help a lot.
Yeah. Well, let's just use those two cases as an example.
Yeah.
I was involved in the Lamoille Valley Rail Trail. This, of course, is the abandoned railroad bed that stretches from Swanton to St. Johnsbury.
Right.
And the proposed alternative use was going to be a recreational trail. What a great use. I hike and mountain bike. Wonderful. And in the winter, it would be a snowmobile trail. But in my professional career, I became involved in sorting out what's called Act 250 jurisdiction. Does it need an Act 250 permit? And without taking everyone into the weeds, I worked with two of my peers because the project crossed through 3 different Act 250 districts, and we decided that it did trigger Act 250 review. And then subsequently I retired, and then one of the families whose home is located 12 feet from the corridor where all these snowmobiles are going to go, was involved in the Act 250 process. So I was not there representing them, but I was observing the process. And the final involvement in that case was something that I still have a lot of trouble with. The Natural Resources Board, the Agency of Transportation, and the Attorney General's Office just a few months ago dissolved Act 250 jurisdiction, frankly, without any legal basis to do so. So there was a public comment period. A few of us commented. What's the basis for this? I filed 6 pages of comments, and then I did a request under the public documents law for this to find out, well, what was the reasoning? And there's no transparency. In each of the instances, the 3 responded by saying it was all subject to attorney-client privilege. So to this day, nobody knows how the settlement agreement was entered into. And again, I hasten to add, I think it's a wonderful project, but in Vermont, the law is the law, and that the impacts should have been given some sort of scrutiny.
Yeah, because I was the chair. I had to step down for family reasons about a month ago, but I was the chair of the Barrie Bike Path Committee.
Yes.
And even though we were doing it in segments, because it's contiguous and more than 10 miles?
More than 10 acres would have to be involved.
10 acres, I'm sorry. I knew there was a 10 in there somewhere. Yeah. We had to go through Act 250 for each segment. So are you saying?
No Act 250.
No Act 250 now.
Right. No Act 250 for that project because the totality of it is less than 10 acres. The other case, the Northeast Materials Group, involved with Rock of Ages. Northeast Materials Group is a state of Washington corporation that makes asphalt around the country and several. And I hasten to add that the folks in Graniteville who I've been helping out recognize that asphalt is very important to all the communities. Everybody likes paved roads, and it's an important thing. But the problem up there has been that, number one, there has never been an asphalt plant in the village of Graniteville before. And secondly, despite the claims of Rock of Ages, which was then Swenson Granite, that they had pre-existing crushing operation, and despite the fact they're represented by a fleet of attorneys, the only proof they ever had for pre-existing crushing up there was a photograph from 1920. No contracts or anything. So to cut to the chase, I was dealing with people that were 4th-generation Vermonters in the village of Graniteville, had never seen crushing. Now they were dealing, and there's a sad irony here, with dust on their dining room tables with the silica content, which killed their grandfathers working in the quarries. And so the whole battle here has been not to say no. The whole battle has been, why can't we have good corporate neighbors on a 1,500-acre piece of land? Put it somewhere else. The state of Vermont, as policy, encourages future development in the villages. It's a wonderful little village up there.
Oh, it's very unique, actually. I think it's cool.
But, so they're breathing in hazardous air contaminants from the asphalt, the silica from there. This battle's been raging for 6 years. They've been very lucky because the clinic at the law school's been representing them when the thing goes into the court arena. But that's a long story. And so it's very sad because a lot of those people have been accused of being NIMBYs. Like I said, they've lived there for 4 generations. they're just disregarding the Rock of Ages has always done this crushing, and Rock of Ages had not always done this crushing.
Right.
So I've been helping out with those people
good.
because I feel fundamentally it's a great example of environmental injustice.
Was this the crushing of the rocks that they had some big contracts down south to use to buffer against the ocean and against the protecting the beaches?
Same
Was that
rock,
the same?
but not crushed. They were going to ship the rock as is
Oh, I see.
in rail
So that's
cars.
different.
This was to prepare for the rising tides. In fact, they
right.
still are going to do that, I understand.
Yeah, they've been, because some of those contracts are very lucrative.
That's
They're very
true,
big.
right?
So.
And more power to them.
Yeah, right, exactly. Yeah. So I think it's great that you've done this because Act 250 is, I must say, don't take offense, it's very confusing. I've actually sat in a couple of hearings because of projects I've been working on. And I know when I was talking to Annette, I just think it's fascinating sitting there talking about the is it 8 criteria or 10 criteria? 10. And what fits in with what. So why, we have wind tower, we have issues of sound, of habitat,
right.
I'm trying to remember all the things. Why didn't, some aesthetics,
right.
why didn't this fall under the Act 250? Because that's a protection for the Vermont citizen. What else is there?
Well, a couple of comments. Number one, in 1969, when the legislature, Governor Dean Davis and the Republican legislature decided that we needed environmental protections in Vermont, they passed Act 250, but they specifically exempted from Act 250 projects which were going to go through the so-called Act 248 process, Public Service Board.
Public service, right.
And so therefore, the short version is the Act 248 process covers projects which generate electricity and transmit electricity. Therefore, since these wind turbines generate electricity, they were exempt from Act 250. Now, the legislature somewhat had the wisdom a few years ago, and they took many, not all, of the Act 250 criteria and implanted them into the Act 248 process. Well, with rose-colored glasses on, that was good. However, two things happened. One, they put a clause in that said that the Public Service Board shall give due consideration to these criteria. Well, what does that really mean, due consideration?
Right.
And secondly, to give some benefit of a doubt to the Public Service Board, that was not their bailiwick. I mean, the Public Service Board for decades dealt with fundamental Public Service Board issues, the rate structure,
right.
the ability of transmission lines to transmit electricity, so on and so forth. This was new ground for them to deal with environmental impacts. And at the same time they're going up the learning curve, frankly, they made very poor decisions on these environmental impacts. So the long story short is, it's all exempt from Act 250 review.
But there's many people who want to see it
That's
in
true.
Act 250
That's
because
true.
Where else, what I've heard from people who've been on the show, they really feel that they're not being heard in the Public Service Board, that they're being dismissed, I guess, if that's a word or not, but they really feel like their voice isn't being heard. And they feel like, they were telling me that they feel like they're being sort of accused of being climate change deniers. And I think when you look at the people who are opposed to wind towers, it's all over the board. It's not party specific. Right. It's not climate yes, climate no. It's just people that are concerned about their backyard, speaking of NIMBY, but true.
That's right. It's their backyards in terms of aesthetic impacts, but it's also their health.
Yeah.
And also, let's not forget the larger public issues here, which are profound, which is where's electricity going to be sold to? Is it a stable source of electricity for Vermonters? There's a lot of those underlying issues which were just cast aside.
Right. And where, could you answer that question? Would it be going over into the grid or back to Vermont?
We feel that it's covered by the Interstate Commerce Clause in the United States Constitution. Okay. It's a commodity. Just like many years ago, in a somewhat poetic justice decision called Philadelphia versus State of New Jersey, solid waste was held by the U.S. Supreme Court to be protected by the Interstate Commerce Clause.
Really?
Right. So states could not bar another state from shipping garbage into their state because it's a commodity. Right. Well, the same thing with electricity. And we layer into that, too, the federal review on energy. There's FERC. There's all these other dynamics which review. And so long story short is when the electricity is generated, yeah, it's in Vermont. Yes, the generators say it'll provide power for 21,000 Vermont homes, so on and so forth. But there's no guarantee it's going to be kept in the state for the 21,000 homes.
Sure. Right. When they were talking about what needs to be connected from the tower too, that's another whole thing I've never covered on the show, what the infrastructure is from the tower out to the people.
Right.
I mean, that's another whole discussion.
Right.
And in doing this research, I learned about Walter Blucher. Blucher, is that how you pronounce his name? He's an urban planning expert. He was involved in the original drafting of Act 250. And he has this quote. I have to read this because I'm like, I don't think so anymore. Act 250 was originally intended to have a generalized state land use map, not be given the effect of law, but to be used as a frame of reference in preparing and adopting land use regulations.
Right.
I think we've gone off from that, have we not a little?
We have. Well, those were back in the heady days of the violins in the background, you know.
Exactly. I think that was the ideal vision, but I think we've strayed off here a little bit. Do you think?
We have. You know, I think the most important thing from that era when Act 250 passed, we'll never see the state land use plan or a map, but the most important thing people should keep in mind is all those crusty Republicans that passed these laws said, we do not want a centralized bureaucracy making these land use decisions. We want to keep it regionalized and in the hands of the people who live there. And that's been one of the strengths of Act 250, that's these 9 district commissions. These people come from their communities and they deal with land use. It's not run out of Montpelier. It's not run out of a headquarters. And in fact, one important role of Act 250 has been that Act 250 has had this oversight function of the centralized bureaucracies. So, for example, when the Agency of Natural Resources issued these permits, it's extremely rare, but there have been very important cases sometimes where the District Commission has risen up and overrode a decision by the A&R, centralized bureaucratic decision. So, yeah, those were the heady days of the maps and the plans. You're never going to see those.
But community involvement, that was the key, was it not?
It still is the key.
And have there been, I was looking and I know there's a lot of were there any substantial changes to Act 250 since the 70s?
There have been a significant number of changes. Some of them have been the carrot and the stick. So, for example, the legislature, to encourage growth to go into the right places, i.e. the downtowns, the designated growth areas, they raised the triggers for Act 250 jurisdiction. So you would otherwise be exempt from Act 250 if you were going to the right place. So there was the encouragement to go somewhere. However, no one's ever double-checked to see if that's worked. You know, we reduced Act 250 jurisdiction, but did that have the desired effect? And did something fall through the crack, like regional traffic impacts? Who's reviewing that now?
Right.
Another change to Act 250 dealt with subdivision of land. Long story short is it's generally the trigger of 10 or more lots, but in a lot of the rural towns, there used to be this thing called the road rule, that if you were going to subdivide land, no matter how big or small the lots were, if a road was over such and such a length, you had to go through Act 250. Well, that did a lot of good work in the towns that had no zoning and no subdivision. That was changed for a bunch of reasons and done away with, and now there's been a real spike in that type of subdivision going on in these towns which really have no local control. There are still some towns, believe it or not, with no zoning.
Really?
Let alone subdivision regulations.
We have zoning in Berlin. we have, actually, Berlin's in pretty good shape,
it is in
I
good
think.
Shape,
It is. They've worked really hard over the years.
Yep.
So last legislative session, Act number 47 was passed.
Right.
And it created a thing called the Commission on Act 250, the next 50 years. You must be tracking that, I think.
I am. You know, and a couple of comments on that. You know, over the years, we've always heard about permit reform. And sad to say, you know, I think permit reform has so far not gotten anywhere because of massive distrust by the two extremes.
Right.
One side sees any and all environmental regulation as adverse to any economic growth, and the other side sees any development or subdivision of land as detrimental to the quality of life.
Right.
And everybody lines up among those two poles, and so it's been this gridlock. I always look at permitting in Vermont as this three-legged stool. Act 250 is a leg, A&R is a leg, and local permitting is another leg. And in the past years, there's always been these studies of Act 250. Here's a factoid. Years ago, during the peak of Act 250 jurisdiction, at most 40% of all development and subdivision in the state went through Act 250. That means 60% of all the development and subdivision was never subject to Act 250 to begin with. And it's even less now. So who does most of the work? Local control, the zoning.
Right.
And Vermont's what's called an enabling state, that the towns cannot adopt zoning or subdivision without being empowered by the legislature, which brings us to Title 24 VSA Chapter 117. So the legislature did the good work of enabling all this 40 years ago, but there's never been a study as to the effectiveness of local review processes. Does it work? What's the quality review? There's a good question for permit reform. And then finally we have A&R. You know, A&R has some wonderfully trained scientists and technicians working there. But I don't want to shock anybody saying that's also one of the most one of the most agencies most subject to political pressures.
Well, they've got both sides of an issue too, right?
That's right.
We just did a show, a debate on leg trap holds and anti-leg trap hold people, and that was they're both sides, and they would all be within A&R's jurisdiction.
Right. So then we have the stool with the three legs. So now we have Act 47, and it's focused again on Act 250.
Yeah.
So I've been to several of the meetings that the Legislative Commission has had so far. They're finding their bearings. They're trying to establish a course of action. They are going to take the show on the road. There's going to be several public hearings. Because
I was going to ask you, how do you? I didn't know about this till I was researching for the show, and I think people would be interested in that.
Absolutely. So there's going to be these public hearings. You know, they're trying to figure out where to go. Frankly, we hope there's going to be a lot of input for other people. You know, I think that with hindsight, when permit reform happened in 2005, this is when the legislature did away with the Environmental Board, created the Natural Resources Board, and more importantly, sent appeals to the Environmental Court. It had the opposite effect. Back then, the reason for doing this was, let's just stop the delays on these appeals and they're too expensive. Well, if you look at the statistics, the appeals to the Environmental Court take forever. It's 3 times longer than what the Environmental Board used to take, and it has really discouraged public participation because people can't afford to go to court.
Right.
And it's a wonderland for attorneys because it's all now procedure. They've drifted so far away from the 10 criteria. So a lot of us hope that will happen through Act 47 is maybe recreate something like the Environmental Board for Appeals, bring it back down to earth. So people have an opportunity to participate, because public participation has been at the heart of Act 250 since the beginning. And Ned Smith, Mark, everybody points out that's one of the purposes for trying to get wind and solar under Act 250.
Do you think they'll look at that issue? Because, I mean, over time, since 1970, when this first began, things have changed. We've got new technologies, and we're going in the next 50 years, we're going to have even more. So they have to look ahead and be more innovative in their head about what's coming.
Well, that's the purpose, they say, of Act 47, preparing Act 250 for the 21st century. You know, one thing I'm worried about is back to climate change, climate refugees coming to Vermont.
Oh, I do know. Who did I have on the show that talked about that? And I had never heard that before, and I went, wow. And there was an article in the paper about that, and people were poo-pooing it, but it made some sense.
Well, I see it in 2 categories. You know, first off, a lot of the studies indicate that, there's going to be effects in Vermont from climate change, but in northern New England, they're going to be more temperate than elsewhere. So I think you're going to have 2 groups of folks moving to Vermont. You're going to have people who are well endowed, who will be able to purchase pieces of land. Where's the pieces of land left in Vermont? Above 1,500 acres, above 1,500 feet in elevation. That's our headwaters areas, that's the aquifers. These are the same areas being impacted by the wind towers.
Right.
So no one's preparing for that. And then secondly, you're going to have people from the lower income groups trying to find a better place to live, coming into villages and cities. So I understand what the governor's talking about because of demographics. We need to encourage people to come to Vermont. But be careful what you wish for, or at least let's get ready for this.
There's just so much we can handle. Right?
So I hope Act 47 focuses on that.
I thought when, I think it was it Wendy Wilton? Somebody said that on the show, and I said, who even thought of that? I never, but it makes sense.
It does. It's coming.
Yeah. Oh, my gosh. Anyway, you talked about permit reform, and you've sort of answered my question about why, because people are hunkered down, right? Because I thought after Irene, what everybody did with the roads, and they just get it built, that next year in the legislature, I said, for sure, we're going to do something on permit reforms. Not one thing. They just hunkered down. And when we were trying, you would remember this, we were going to merge Central Vermont Chamber of Commerce with Economic Development.
With the Regional Planning Commission.
Regional Planning Commission, and I was supportive of it, and we went around to all of the different select boards and stuff. Oh, my word, people were berserk about it. And they said, absolutely not. And I said, first of all, to ruin the environment, if you have half a mind of business and making a profit, you don't want the environment to go, because what's the draw for Vermont? It's the environment. It's our skiing areas. It's all those cool things. So why would you shoot yourself in the foot and make it a not nice place to visit? And why can't we find a balance? But they didn't believe me. I remember one in particular. I shall not mention the select board, but it wasn't pleasant. And they just didn't. It was a matter of trust. They really didn't trust either one. Trust the other side. So, so how you've got these people who want to make it? Do you think the Act 47 will be the opening of the door to get the wind towers in? Or were they just, is there a reason why the Public Service Board wants to retain it?
You know, I find it's going to be extremely difficult although one would think that the Act 47 process would be the ideal process to have the discussion also about industrial scale wind and solar.
Right.
I don't think it's going to happen because of the rigidity that still exists in the State House. I think that what some of us call the green energy lobby still has a lot of strength over there.
I mean, do you think there is room for industrial-sized wind towers, or are you just hoping that they discuss it?
Well, for me, it's always been a question about appropriate siting and
I'm
scale.
with you on that, right.
And so I think, and putting on my rose-colored glasses, I think it would work wonderfully if the legislature was to say, you know what, the fundamental siting of these projects should be Act 250. Let's have these 9 regional commissions do it. They've been doing it for 40 years.
Right.
Let's let them do that piece of the puzzle. And let's do it in such a way that it's in sequence with the Public Utilities Commission doing the traditional Act 248 review. Now, this isn't rocket science because the legislature had this in Act 250 in 1969.
Right.
Since 1969, there's a provision of Act 250 which encourages, if there's more than one state agency that's going to permit something, have coordinated reviews.
Oh.
Hardly ever used. In my career, we did this.
It's in law already?
It's in the law. We did this way back when I had hair in my head. And the project was a marina up in Lake Champlain. At that point, I ran the district up in Franklin County. And we worked well, that commission with the Water Resources Board, in doing a joint review. There's really no reason in the world, if there was a will to do it, that Act 250 could do the review of the ecosystems, the health impacts. There's all the history in Vermont. It's all been done under Act 250. It's all been to the Supreme Court and reviewed and fine-tuned. Give it back to Act 250, and let's do this in a coordinated fashion, so when we get to a certain point, then the Public Utilities Commission decides what's the rate structure and will this work?
Because I think there's 1.5% of projects that go before the Public Service Board is denied. The rest are all, and there's the word rubber stamp that I've heard, so I'm just repeating what I've heard, that they need another process because they don't think this is working.
But on that note, I will say this, that Act 250 from the beginning has always been designed as a permitting process. Contrary to the image out there that it's to stop growth, so on and so forth, Act 250's purpose has always been to protect financial resources and ensure quality development subdivision. But the point I wanted to make is the denial rate under Act 250 is less than 5%.
Oh, really?
So 95% of the project get approved by Act 250. Now, some will hasten to add, but some of them have permit conditions that might just have the same effect of killing the project. There's a big debate about that. But statistically, less than 5% of them are denied under Act 250.
I just remembered one thing, and this is slightly off of the subject, but doesn't Act 250, if you have a development and a new business comes in and that development wants to do something else, everybody has to share in the cost of the as part of the Act 250 and to pay for the upgrades or whatever they're doing. I remember that was a big issue in Berlin when we had the Four Corners, and one of the companies, the mall wanted to do something, but it dragged in everybody. I'm not explaining this well, and I apologize.
Those are,
you know what I'm saying?
Yeah, they're typically the infrastructure projects. So if some developer wants to, for example, connect its project to the municipal sewer, but the municipal sewer connection is 1.5 miles away, the developer has the capital to run the line to its project. Well, there's 1.5 miles now that has access to a sewer line, which one side will say will accelerate development. The other side will say, well, it's good. It's better than an in-ground septic system. And there's truth to both of those. But the point is that Act 250 says, okay, if you want to connect to that line, incremental development has to be reviewed. We cannot have this happening.
And everybody
helter-skelter.
shares in the
That's
cost.
correct,
Yeah, right.
And it's worked.
That was an issue in Berlin.
It sure was.
I think
It'll be my book.
You explained, but you have got so much knowledge, Ed. You should do something with it. One other question. They were talking about Met Towers. And what are Met Towers, and the fact that the Public Service Board does not use the data from the Met Towers to help in their decision-making process, or so people have said.
MET is short for meteorological. They put up a tower that literally measures the direction of the wind, the strength of the wind, to ascertain whether or not that's a good site to put up a wind turbine project. And there's been a lot of controversy as to whether the Public Utility Commission has required them to get a certificate of public good. And in the instances where an application has been filed, did the Public Utility Commission do a good job? I hasten to add, there's always been a comparable provision in Act 250 that says, well, if you're doing some sort of improvements which are for investigation, for preliminary work, you may not need an Act 250 permit to do that. So it's really murky. But one of the problems, which is startling to me, is if you go in and look up the statutes, which are the Act 248 process, there's hardly any definitions. I was trying to look for a definition of a Met Tower today. There's no definition.
Oh.
They fly by the seat of their pants. You go to Act 250, there's pages of definitions.
So what is the, so it's, but it's good to have that data though, right? Where you know, they were talking about the measurements and what it collects, and they should take a look at that wind velocity and that sort of stuff, because there is some waves that come from the towers that could really impact somebody's health, correct?
That's correct.
Yeah, and it kind of comes in waves, actually, and it impacts at different velocities at different times of the day.
Right, now that wouldn't be determined by the Met Tower.
Oh, really?
Those impacts come from the blades on these turbines, and people don't realize, because when you look at them, you know, people still call them windmills. You expect to see this little Dutch boy and little Dutch girl come trotting down the road. But when you go up and look at these things, those blades
huge.
are enormous.
Yeah.
And when they spin at incredible speeds, because you're looking at it from 1.5 miles away. But when you're up there, they're whipping around.
Right.
So they create sound because of the configuration of the blades, depending upon forest cover, the terrain, the topography. One side of the mountain might not hear anything. The other side, it's terrible impact.
Well, that's what happened in Lowell, right?
That's right.
And they wouldn't let the people on the other side of the mountain participate.
Right.
But they heard the sound.
Well, as you mentioned, the family Terrians were driven out of their home.
Right.
Another family named the Nelsons were subject to a buyout by the utility, but they had to sign a non-disclosure form. They couldn't talk about the impacts on their lives.
That is, I'm sorry.
Yeah.
That's very wrong. So I read this, and I was very surprised by this, because you mentioned public good. And most of the rules are meant to look at the general public, what's average for the general public. But in wind towers, they look at individual. You're an individual when you go before the Public Service Board, not representing the average Joe or the average person. And so how does that work if you're looking for a certificate of public good, which means more than one? How does that work where they can take you as an individual? So whatever you say, like these people that had to move out of their house and the people that had the non-disclosure, it's just them and not me living next door to them.
So the Public Service Board says if you want to participate in our review process, you have to qualify for what's called standing. In Act 250, that's called party status. So you as an individual have to cross an initial hurdle that there's some sort of real-life potential impact on you as an individual. But you're not here. We're not going to let you participate for the general public. It's just for your piece of the world and impact. On the other hand, this concept of the public good goes way back to the era of rural electrification, when we were running these poles and lines through farmers' fields and all. And everybody wanted electricity, right? Nobody can argue with that. But that was the birth of the concept of the public good, something that was overarching. Yes, some people's toes might be stepped on, there might be some impact, but because of the larger community benefiting, that's the public good. So they sound like they're the same, but they're very different concepts.
Oh, I see, because I didn't understand. I thought that was selling the individual short, where if I'm sick, you're looking just at me, but the rest of the community could be subject to the same ill effects.
But here's the rub. I mean, even if you got party status before the Public Service Board, you would only be allowed to participate as to the impact on your interest. You would probably not be allowed to talk about the larger impacts, like is the electricity staying in Vermont?
Right.
Or what about the fact that you only can make electricity when the wind blows, right? Yeah. Which means that there's a power plant sitting on line somewhere, either fueled by natural gas or some other fossil fuel. So when those blades stop turning, that has to kick on, right? Otherwise, everyone's lights go out. Well, you would not necessarily be allowed to even ask those questions on behalf of the public good because you're standing...
Just me, because I can only talk about me.
That's right.
That makes sense. I will say one thing, though, as we're talking, I'm reminded of a big project in Berlin, which you probably know, and how people with individual interests held up that project for a very long time. And a lot of money was spent by the developer to try to keep things going. And I think that needs to be looked at because it's not that much money to become a party. And so you can pretty much hold up a project for good reason or not. There's got to be somebody that says, you've had your day in court, let's move on.
Well, you know, my experience was probably once in a blue moon, there would be a party sufficiently endowed financially to play that game. You know, ironically, the ones that used to do that most often were developers themselves.
Oh, really? For competition?
That's right.
Oh, great.
But the vast majority of these delays that these mythological delays, you know, in my experience, caused by the developer himself, herself, itself, by not getting the district commission revised plans in a timely fashion. It'll be in the book.
Okay, that wasn't my understanding. I'll talk to you later.
Okay.
In fact, what I found interesting, and back in 2005, two names that you'll remember, Representative Hudson and Representative Peasley, put in bills to make this happen, to get wind developers to be part of Act 250. Right. And I thought, how can this be back in 2005? This is like forever, ever.
Right.
When does it's got to stop? Because
I think what happened then was simply bringing up another layer of review, set off alarm bells in some people's minds on both sides of the aisle. Increased delays, increased costs. We're not going to touch it. It's a third rail. Sad to say, though, that it probably would be to the benefit of the developer, as we've already discussed, if the fundamental siting reviews were done by a district commission. So, yes, they stuck a lot of the Act 250 into the Public Utility Commission review. They don't do a good job, and all this unnecessary litigation results from that.
So I just want to go back a little bit to the barometric pressure waves we were talking about, where I had read stories about people feeling seasick, about that there's no way to really look at the acoustical profile to really make a statement of this is making me sick. It almost sounds to me like, I think IBM did this in some of the companies where they took down the walls in their facilities, and they did this white noise, they call it, where there's this little hum in the buildings where people, you can't hear next to you or something. But this sounds like it's way more than that, that it's really impacting somebody's balance and being nauseous.
All sorts of physiological impacts, not by everybody, but not everybody's the same, right?
Right, sure.
So different assortments of impacts. The ones I'm most familiar with are impacts on people's ability to sleep, which can set off a trigger of other adverse health effects by not being able to sleep. You know, when you look at what's going on in other industrialized countries, they have more stringent sound impacts. It's very frustrating to me because organizations that I've usually worked with over the years, such as VNRC and VPIRG, when I first went to the State House in this issue 5 years ago, I said to them, you know, we should all be establishing forums to talk about this stuff. Otherwise, we're all going to be at each other's throats down the road. They saw nothing to talk about, right? Because they had the votes. They already had the laws in the book. You know, energy self-sufficiency by whenever that is 2050. They were not going to do anything to reopen the statutes. And, politically that made sense. But unfortunately now look where we are in this state, having this absurd debate. When I was in the State House, when I first went there, I suited up, And these youngins, everybody's younger than us these days, would come up to me and say, who are you working for, the Koch brothers? Ed Stanak working for the Koch brothers? My wife
lightning
would
will
boot me out of
strike.
the house. But that's the very sad state in Vermont. You know, we should be looking for the common good.
Right, I'm right with you, Ed. Scary though that may be, we're on the same plane on this one. And the one thing that I read mostly is that and I've actually been at these meetings where developers, and you just met, developers come in and they say, I'm going to build this project and it's going to do this. And they've set out measurements of the sound and all the stuff we've talked about.
Right.
But there's no mechanism to hold them accountable with, are they meeting their stated and promised standards? And so you buy into this.
Right.
So
well,
how do you fix
two
that?
responses to that. The first one that comes to mind is enforcement. You know, the state of Vermont is supposed to step up to the plate and enforce the law. That if someone gets a permit or a certificate of public good, whether it's an Act 250 permit or what have you, if the developer is not doing the way it was supposed to be done, the state should be enforcing. Easier said than done, though. That has become such a difficult process over the years. It used to be, if it walked and talked like a violation, at least a notice of alleged violation was put out there to get it into that arena. Now the agencies are very, very reluctant to enforce because they see this as like raising constitutional issues. I mean, it's ridiculous, you know, because there are so many layers that would protect an individual from abuse by the bureaucracies. Right. So the developer says, I'm going to do it this way, it doesn't work out. They say, oh, that's the way it goes. And the agencies are really doing a poor job of enforcement.
What does that got to do with the Constitution? What is that? I'm sorry, sometimes with these discussion about freedom of speech, I have to do a show on that sometime. I mean, there's a point. If you're saying to a group of people, I'm going to provide you this, and you don't, I think they're not telling the truth.
Some of the developers will always raise the taking issue. You know, I have a permit, and what you're doing now, because I have a permit, and telling me to stop doing it that way, it's diminishing the value, it's therefore a partial taking. I've heard that argument made, it's a taking. Or it's inadequate due process. You know, by having an administrative order going out saying you're in violation, that's not adequate due process. Everything has to be now litigated, which brings us back to the environmental court. The environmental court in Vermont, quite frankly, is so overloaded that in all practical effect, it's broken right now. When you look at its docket, it's staggering. That court, 2 judges, now hear the appeals of Act 250, zoning, A&R permitting. It's ridiculous.
Right.
And then they're supposed to deal with enforcement. The other answer to your question about if the developer says, I'm doing it this way and they don't, is at least in the world of Act 250, it's called a material change. And we would tell the developer you have to file an amendment to that permit because everyone's entitled to now have
a say in that, right?
A review of how you're doing it as to how you said you were going to do it.
So what would Ed Stanak like to see about this issue? Because you've been working really hard on it, and are you going to speak up in front of the Act 47 board? Is that the... Yeah.
I will be. I've written them already, you know, making some suggestions. As I mentioned before, I think it was a noble effort to have this Natural Resources Board, but it's really not working for several reasons, which we won't go into now. And I feel, many of us feel quite strongly, there's a lot of wisdom to go back to a citizen board that would hear the appeals. It will return it to being more fact-based. The developer and the party's legal rights are protected because there would still be an appeal to the Supreme Court. So the legal issues could be dealt with by the court. No one's losing anything there.
Because the Public Service Board feels it's sort of doing the right thing, but maybe if you don't want to turn everything upside down, you just make the rules a little bit different in the Public Service Board, and just if that's what they want to do.
Right. And again, you know, by putting the siting review for the industrial scale wind and solar in Act 250, there's a strong background there. There's all precedents for 40, 50 years. You're not reinventing the wheel.
Right.
There's all these precedents, which the legislature said when they passed permit reform in 2005, that all of those decisions are binding on the environmental court. So they're carved in stone. Right.
So Diane Snelling, could you explain to people what she is? She's the chair of?
Diane Snelling is the chair of the Natural Resources Board, which is the entity created by the legislature. When it eliminated the environmental board, the Natural Resources Board is sort of like responsible to oversee the 9 district commissions.
Okay.
It also has automatic appeal status for any jurisdictional or permits which were appealed to the environmental court.
Okay. And then to the Supreme Court?
And then to the Supreme Court.
Right. Interesting.
Yep.
Very nice.
Yep.
So What's the solution here? I mean, you've already given us some ideas about what do you think might fly in this
Well, the thing that
environment?
excites me is all of us green investors having found each other. You know, it's a wonderful experience. For me, it's the same thing when I used to live in Marshfield as going to town meeting.
Yeah. Oh, I love
And
town meeting.
it's, you know, you go to town meeting and everybody finds the common ground. You have to, because you realize we got to do the best for the town.
Right.
Well, that's the great thing about the green investors, you know, like Ed Stanak and Brian Doobie in the same room, right? Who would have thought?
You could find things to be buds about, right?
But it's great because when you get together now to talk about industrial wind and solar, it provides the opportunity to talk about other stuff.
Right.
That's great.
Because he is very active in the wind issue.
Right.
I've read a lot of things that he's written. And
His wife Penny, I've gotten to know her well.
Right. Yeah.
Yeah.
That's
Yeah.
great.
Yeah.
Now you mentioned 3 times. I'm thinking the word book.
The what?
Are you writing a book? Come
No,
on,
I'm
Ed.
not writing a book. But, you know, in my dark humor days, I used to kid with the attorneys and developers about the Act 250 movie.
Oh, God, stay tuned.
So the big joke was everybody would choose which actor or actress was going to play them.
Ed, do you realize all of the things you've been through in how many years? You said 30?
32.
Oh my God. Yeah. Well, I know that you are very highly respected.
Thank you.
So I hope that you do something with all that's up there in that brain of yours, because it's amazing what you remember.
Yeah.
As I've been to a few meetings and I couldn't remember a thing. All I know is there's like environment. There's some key things. Could you quickly, if you can do this, I'd be impressed. Take the 10 criteria and can you list them?
First criteria is air and water pollution. Water divides into everything from headwaters, waste disposal, streams, shorelines, wetlands. Criterion 2 and 3 deal with water supply. Is there enough water for the project? Is it going to hurt somebody else's water supply?
Oh, we had that big time in Berlin when we were doing our digging wells for our new water supply.
Yep.
That was interesting.
Yep. Yeah. Criterion 4 deals with erosion, and if the runoff is going to flood out somebody else down the street. 5 is traffic. 6 and 7 are impact on schools, municipal services. Criterion 8 deals with a range of things, including those rare aerial placeable areas on top of the mountains, but also aesthetics. This is another thing with industrial scale, which absolutely blew my mind when these youngins, everybody's young, and people come up and say, you know, beauty's in the eye of the beholder with these windmills, you know, on top of the tower. And I said, beauty's in the eye of the beholder. I don't mean to insult anybody from the Chamber of Commerce, but I said, that's what we used to hear from the Chamber of Commerce attacking Act 250 in the 1980s. But the serious point is this. All right. So is aesthetics too subjective to be reviewed? Maybe it is, right? Well, the U.S. Supreme Court, we knew in the 1960s, said, well, we don't think so. In a famous case involving the Penn Central train station, or the Grand Central Station in New York City, that went to the Supreme Court, and the Supreme Court said that aesthetics are absolutely constitutional. They're not subjective. So back to Act 250. When aesthetics were challenged in the famous case called Quechee Lakes, a condo project in Quechee, that went to the top of the heap in Vermont, the Vermont Supreme Court, and the Vermont Supreme Court in a decision held aesthetics are not subjective, that there is an objective lens that the Environmental Board has created, which is perfectly legitimate and acceptable in Vermont. So we do have under Criterion 8, the strength of Act 250 has been the aesthetics. But now people are saying, and it's so sad, you know, that the mountaintops should be sacrificed.
They don't grow back. Does anybody
because of
know
what?
That?
We have this now quest for an infinite supply of electricity?
Yeah.
Or we're going to save mountaintops in Virginia by destroying mountaintops in Vermont?
No, and that's what we're famous for,
right?
Is Camel's Hump and all of those mountains. And somebody told me, I mean, the trees, and that's part of the air we breathe. It makes it cleaner, and the runoff. That's all part
Steve
of
Wright,
it.
one of the green investors, who used to be the Commissioner of Fish and Wildlife and used to work for the Federal Fish and Wildlife Service, has a great analysis about how the mountaintops are absolutely critical for our future because they're carbon sinks. They're going to be what helps us get through all the impacts of climate change. But you know what happens, and we saw this with the ski areas, that when you begin nibbling away in those high elevations, you have things called, for example, blowdown. You move some trees, and other trees can no longer sustain the wind. They fall down. You have an invasion of, they're called invasive species of plant life. Seeds get up there. I tell you, one of the most tragic outcomes in Vermont was when Vermont led the country now. We established a precedent for the use of the national forest land for energy generation.
Really?
Down in Searsburg, where they put the new turbines on national forest land. that opened the gate, which is going to come back to haunt us, because now I know in Ohio there's a gas fracking corporation that's pointing to that precedent to say we should be allowed to go in and drill and frack gas in a national forest in Ohio. So
be careful what you ask for.
That's right, but now energy is energy. So now how is the Green Lobby in Vermont going to explain that to future generations?
Right.
We've opened the door.
Right.
All energy is equal.
Well, they were talking about the floods, the mudslides in California were a direct result with the forest fires, because
Correct.
there's no trees to stop the flooding. So
I tell you, Searsburg is tragic.
You're making me depressed, Ed.
Well, Searsburg is tragic too, because it's a national forest land that we all own, right? When they constructed those turbines between 2,800 and over 3,000 feet in elevation, they destroyed this very important regional black bear habitat.
Oh.
And I mean, they didn't flatten it all, but they did flatten a substantial amount of beech trees, which are important for the species to fatten up before winter comes. But also, there's a travel corridor, which is going to, some biologists feel, is going to break the genetic strain of a segment. So, precedent to develop energy in national forest, destruction of a black bear habitat. It's tragic.
Oh my gosh.
And we set the framework for this here in the La La land of Vermont.
Obviously people testify. Who's listening? They're not, are they?
Well, that's an interesting case, because my understanding is that this has been that went on for 10 years. Then initially the Department of Fish and Wildlife in Vermont took the absolutely correct stance. But as I mentioned a few minutes ago, A&R sometimes is subject to political heat. We had a change in who was governor, and suddenly Fish and Wildlife went in the other direction. It was a miracle, right?
I'll tell you a great story about when Governor Dean and Governor Snelling and Governor Dean, and I was in personnel, and the first year I went, we hated something. Second year, we loved it.
It's amazing how that works.
Yes, it is. But the second year, I didn't want to look like I didn't know what, I wrote a letter from the governor that said we loved it, so I covered myself. But that's how it goes.
That's how it goes.
I have to tell you, I don't think people have a clue about how big these things are. My husband and I rode our motorcycles up to Prince Edward Island, and right on the water, they've got, I don't know, a whole bunch of the wind tower. And we were able to ride our motorcycles right near the boxed-in gate on the bottom. And if anybody ever felt like an ant, you are this big compared to those things. It's just hard to look up. They're huge.
The ones sitting on the mountaintop in Lowell are the equivalent of 50-story buildings.
Oh, wow.
50-story buildings. Are there any 50-story buildings in Vermont?
No, we wouldn't know what to do with it. Wow, that's amazing. Ed, is there anything else in the time we have left that we should cover? Oh, can I ask you a political question as far as Washington, D.C. goes? Are you ready for this?
I'm ready.
Solar panels and the, what is it called? The president put tariffs on the incoming solar panels from out of the country. And I heard some discussion on the radio today that was a kill the solar industry, and I'm assuming why he was doing it was to give the United States manufacturers a leg up. But
That's correct.
Can I put you on the spot?
I can't believe I'm going to say something in favor of Donald Trump, but here we go.
Thank you, Pat.
So, relying on that major source of fake news known as the New York Times, they did great coverage of the tariff thing. And in fact, what happens when they manufacture these in China, besides casting aside environmental laws, besides having absolutely hideous working conditions for the Chinese that manufacture this stuff, they were selling it at such a rate that it was destroying. So there's 2 American solar manufacturing companies who would benefit from this because of the tariffs. Now, some of the industrial solar advocates in Vermont are saying those are foreign corporations. The New York Times says they're 2 American corporations. So it's not going to destroy, I read somewhere, they're alleging it's going to destroy 23,000 jobs. In fact, it could have the opposite effect, that there will be more people hired to manufacture the panels in the United States of America. And with
Bring business back to the United States,
and with respect to the economic impact, which some say this is going to destroy the industry, that New York Times analysis said that at worst, it would increase the cost of industrial scale solar by 10%, and residential rooftop solar only by 3%.
Wow.
So is that going to destroy the industry?
Not really.
I don't think so.
Yeah, okay. I wasn't sure when I heard that, and I said, I'm going to ask Ed. Ed, you have been delightful. I don't know, do you have some extra things you wanted to talk about things we missed?
Well, the only thing I would say is, as I mentioned, 8 years of Jesuits, right? And so there's a
Exactly.
concept called the beloved community, which was also a concept during the whole civil rights movement. And for me, it's what it's all about here in Vermont. You know, we're all in this together. We ought to find the common ground because we're responsible for the future generations. We're responsible for these ecosystems. We've done a pretty good job so far. It'd be a shame now in the rush for what we think is the best thing. We should slow down and think about it because the larger community really depends upon us.
That's great, Ed. Thank you very much.
Thank you for having me.
It's been a pleasure. Thank you all for tuning in. We'll see you next week. And in the meantime, keep listening beyond the sound bites.